Well, welcome to all of you to our panel on disparate impact. And I thought maybe we could begin by giving the Federalist Society and those who have organized this whole convention a round of applause for what I think has been a day very well spent. So congratulations to all of you who organized this event today. Our topic, as I mentioned, is the disparate impact approach to interpreting and enforcing the civil rights laws. It's been a source of controversy on the Supreme Court and elsewhere ever since Griggs versus Duke Power 48 years ago, which interpreted Title VII to include disparate impact. And it remains controversial in many circles today. We are fortunate to have three widely respected experts with a variety of viewpoints on this issue to help us find our way through the controversy that sometimes surrounds this issue. My name is Gene Schaerr. I'll be the moderator. Our first speaker will be Roger Clegg, who is the president and general counsel of the Center for Equal Opportunity. He focuses on legal issues arising from civil rights laws, including the regulatory impact on business and the problems in higher education created by affirmative action. And I have firsthand experience with Roger's expertise in this area, since when I was in the White House counsel's office during the Bush I administration, he would often visit us to talk to us about the then pending civil rights amendments. He is a former Deputy Assistant Attorney General in the Reagan and Bush administrations. He also held the second highest positions in both the Civil Rights Division and in the Environment and Natural Resources Divisions in the Justice Department, as well as several other positions, including Assistant to the Solicitor General, Associate Deputy Attorney General, and Acting Assistant Attorney General in the Office of Legal Policy. His topic today will be to give us some background on this whole issue, as well as talk to us about the pros and cons of the disparate impact approach, mostly the cons, I believe. Roger.
Thank you very much, Gene. It's good to see you again, and thank you for that nice introduction. And you were quite right. I will give the definition of what the disparate impact approach is and a little bit of the historical and statutory background, and then move on to some of the pros and cons. I think that most of the pros are going to be handled by Ted. The cons, Gail and I have divided up. I'm going to talk about why disparate impact causes cancer, and she's going to talk about why it's unconstitutional. So that's the basic division. The disparate impact approach to civil rights enforcement says that a practice that has a disproportionate result, statistically disproportionate result, whether it's on the basis of race or sex or color or religion or whatever category you like. If it has that kind of a racially disproportionate result, it is illegal without having to show that there was actual intentional discrimination or disparate treatment on the basis of that category. And the presumption of illegality can be rebutted only if some degree of necessity is shown for the practice. So again, it doesn't matter if the practice is neutral on its face, is neutrally intended, and is neutrally enforced. If it has this kind of disproportionate result, that is enough for it to be illegal. And intent is irrelevant. If you are the defendant and you prove that you adopted this, again, without discriminatory intent, and you're enforcing it even-handedly across the board, and everybody, and there's no racial, nothing about race in the standard itself, that doesn't matter. The approach, as Gene indicated, began principally in the employment area and in the voting area. The Griggs decision by the Supreme Court in 1971 first said that Title VII of the 1964 Civil Rights Act does not require showing of discriminatory motive. And it had already been the case that the 1965 Civil Rights Act, at least in Section 5, prohibited things that had the effect of racial discrimination, as well as things with discriminatory purpose. However, that approach soon spread to other areas of the law as well. And it was used in the Fair Housing Act, for example, although the Supreme Court did not recognize disparate impact causes of action until just a couple of years ago, but it was found in a lot of lower court decisions. And many agencies used the disparate impact approach in their regulations, even under Title VI of the 1964 Civil Rights Act. Title VI applies to federally funded programs, and those programs are administered by different federal agencies, and many of them have regulations for the implementation and oversight of those programs that use the disparate impact approach. However, the Supreme Court has said that Title VI itself, the statute, is a disparate treatment statute. You can violate Title VI only through intentional discrimination. And so there's this question out there, which Justice Scalia raised, and rather quizzically a couple of decades ago, saying it's rather odd that we have this statute that prohibits only things that involve disparate treatment, and you have regulations that are prohibiting something that the statute itself involves. However, and then he went on to rule that there wasn't a private right of action in that particular case. So, you have this approach in employment, you have it in housing, you have it under a lot of Title VI programs, which include school discipline, which has been in the news lately, language requirements in, for example, driver's license programs. Can you require that driver's license tests be administered in English? Police enforcement, even environmental law. All of these things have had the disparate impact approach applied to them. During the Clinton administration, it was applied to pizza delivery under Title II of the 1964 Civil Rights Act. I don't think that generally courts have not recognized public accommodations as an area where the disparate impact approach has been applied, but you do still find that application now and again. Supreme Court has explicitly rejected it in a few instances. I already mentioned Title VI. It's also said that you cannot, that the 42 U.S.C. Section 1981, which deals with contracting discrimination on the basis of race, requires there to be actual intent. Well, so that's a sort of overview of what the legal landscape looks like. And so now I'm going to pivot and talk a little bit about policy. Just to anticipate a little bit of what Ted is likely to say, I think that one of the justifications for this is that it's that's often given is that it's hard to find a smoking gun, the kind of smoking gun that you need in order to prove disparate treatment. And so therefore, the disparate impact approach is needed as sort of an evidentiary tool. Another argument is that, well, what's the big deal? The defendant doesn't automatically lose. As long as you can show that he's got a good reason for this policy, he can still win the lawsuit. And then a third argument that's frequently made is that, not only is getting rid of discrimination itself a bad thing, but any policy that keeps us from, having more integration, more diversity is a bad thing. And if a policy has that effect, why shouldn't the person who's adopted the policy have to show, a really good reason for it? I don't buy any of those justifications, but I think that that's a fair statement of the justifications that are given. The problems with them, and I could go on forever. Let me know when I've got about 3 minutes. Okay. Okay. Well, I'll try not to go on forever, but I'll label some of the problems here. The first one that Gail likes to make, so I'm going to steal this from her, is that everything has a disparate impact. There's no selection device that you can think of that isn't going to have a disparate impact on somebody. So it seems a little bit odd that you should put employers in the position of being open to a lawsuit, literally, no matter what selection device they choose. Another problem with this approach is, the obvious one that you may have very legitimate practices, very legitimate criteria that happen to have disproportionate results of one kind or another. Why should we be telling businesses who are not actually discriminating on the basis of race that they can't adopt a policy that has a legitimate purpose? Another problem is, and I think that Gail is going to talk more about this, is you are telling employers implicitly or really explicitly that they need to get their numbers right. The civil rights laws are supposed to be all about discouraging people from making decisions with an eye on race. It's supposed to be all about discouraging people from deciding to take this course rather than that course because of the racial results that it's going to have. We're supposed to be encouraging people to ignore race in making decisions. And yet the disparate impact approach requires them to consider what the racial results are going to be before they can adopt a particular approach. With respect to the arguments that are put forward, it's simply not the case. I mean, Ted and I both worked in the Civil Rights Division, and he brought and I brought disparate treatment cases all the time. It is not difficult to win a disparate treatment case. You don't have to have the disparate impact tool in order to enforce the civil rights laws. It's also, I think, not fair to tell employers that, well, look, all you have to do is just go to court and win a lawsuit if somebody challenges it. Lawsuits are expensive. They're dangerous. Sometimes you lose even when you should win. And who knows what an unfriendly judge or an unfriendly federal bureaucrat is going to do. There are also sort of coherency problems or coherence problems with this approach. I mean, consider the Fair Housing Act, for example, and consider a say some kind of landlord policy that excluded people that had a criminal record of some kind. Well, that could have a disparate racial impact in one city, but not have a disparate racial impact in another city. Or the fact that it had or did not have a racially discriminatory or racially disparate impact could change over time. It might have no racial impact in this year, but then 10 years later, it might have a disparate impact. And then there's the problem of defining which group. I mean, for example, it might have a disparate impact on Asian Americans with respect to, as opposed to Latinos. But maybe some Latino subgroups, Cubans, for example, did not have the disparate impact on them, and some Asian subgroups, maybe Cambodians, did have the disparate impact on them. So why is it that the legality of this practice, which a company may have, it may be a national company and it administers this program all over the country, and it's going to be legal in some places and not in others, and it's going to be illegal at some points in time and not at other points in times, and it's all going to depend anyway on sort of how you define this or that group. And then finally, another problem in some areas is how do you even define what group is suffering a disparate impact? And this was visible in all of the recent fair housing cases that went to the Supreme Court. One of them involved the city of St. Paul that was being very aggressive in requiring landlords to adhere to health and safety standards. Well, the landlords sued, saying that this has a disparate impact because it's going to require us to spend more money and we're going to have to raise rents, and the people who are going to have their rents raised are going to be African Americans. Well, yeah, I guess that does have a disparate impact on African Americans in one sense. On the other hand, the beneficiaries of not having rat-infested tenements are also going to be African Americans. This is a point that Justice Alito made in his dissent. Another case that almost made it to the Supreme Court but then got settled at the last minute involved urban renewal. Well, urban renewal has a disparate impact on some African Americans, but it's a good thing for other African Americans. It's the same problem. And then finally, the case that actually got to the Supreme Court involved a fair housing agency that thought that the way that the state was calculating where to place fair housing or low-income housing was having a bad disparate impact because the low-income housing was being located disproportionately in heavily African-American areas. Well, again, what the plaintiff wanted was more racial integration, and they said, well, this is racial integration is a good thing for African Americans, and therefore this has a disparate impact on African Americans. On the other hand, if you are an African American who wanted low-income housing near where you worked or near where you already lived, this was actually a good policy for you. Again, all of these problems are inevitable when you take the disparate impact approach, and I think shows the fundamental problem with defining discrimination as anything other than simply discrimination, that is, treating people differently because of their race or their sex or whatever other prohibited category you have. With that, I'll stop.
Thank you, Roger. Our next speaker, I'm going to have to apologize to her in advance because I didn't verify the pronunciation of her last name. Is it Harriet?
Heriot, yeah. It's Scottish, not French.
Okay, Scottish and not French. That's good to know. Gail Heriot, not Heriot, teaches and writes in the area of civil rights, employment discrimination, products liability remedies, and torts. She clerked for the Honorable Seymour F. Simon on the Illinois Supreme Court, and before entering academia, she practiced with Mayer Brown and Platt in Chicago and Hogan and Hartson in Washington, D.C. She also served as Civil Rights Counsel to the U.S. Senate Committee on the Judiciary and as Associate Dean and Professor of Law at George Mason University School of Law, I guess before it became the Antonin Scalia School of Law. And she joined the University of San Diego School of Law faculty in 1989. She is also currently a member of the United States Commission on Civil Rights, and as Roger suggested, she's going to talk to us about the constitutionality of disparate impact.
Thank you. As he said, I'm going to speak on the constitutionality of disparate impact analysis and what the administration should be doing to tee up the issue for an eventual decision by the Supreme Court. Some of you may remember that Justice Scalia began his concurrence in Ricci versus De Stefano this way. He said, I join in the court's opinion in full, but write separately to observe that its resolution of this dispute merely postpones the evil day on which the court will have to confront the question whether or to what extent are the disparate impact provisions of the Civil Rights Act of 1964 consistent with the Constitution's guarantee of equal protection. Scalia wasn't the first to bring up the constitutionality of disparate impact liability. The issue started getting a lot of attention just after Grutter versus Bollinger in 2003. Before that, quite a few left-of-center attorneys held out hope that the Supreme Court would not apply strict scrutiny to laws and policies that discriminate in favor of racial minorities. As soon as Grutter dashed those hopes, it became reasonably clear that a federal policy that forbids employers from using hiring or promotional criteria that have a disparate impact on racial minorities have to be subject to strict scrutiny. Now, on the other hand, that case also dashed the hopes of right-of-center attorneys that strict scrutiny would be strict. So there was good and bad for both sides in that opinion. Title VII has been interpreted over the years to apply only to women and minorities, and that doesn't bode well for it. For example, the U.S. Commission on Civil Rights flatly stated back in the early 1980s that disparate impact liability, and I'm quoting them here, cannot be sensibly applied to white males, given that the purpose of that liability is to uproot historical and contemporary sexism and racism. There have been lots of statements that are in agreement with that sentiment by academics, or at least there were back before Grutter versus Bollinger. And during the debates over the Civil Rights Act of 1991, members of Congress repeatedly, and I do mean repeatedly, stated that disparate impact was for women and minorities. There are no reported cases that I know of in which a white male has actually prevailed in a disparate impact claim. Okay. If so, strict scrutiny must be applied to the racial part and intermediate scrutiny perhaps to the sex part of disparate impact liability. Indeed, since they were a package deal, strict scrutiny probably needs to be applied to the whole package. I know this has a bit of metaphysical unreality to it, since I don't believe Congress ever intended to adopt disparate impact liability. But if we assume that Congress intended to adopt disparate impact liability back in 1964 and intended for it to apply only to women and minorities, that can't be fixed just by rewriting the legislation to apply to everyone. Congress didn't intend that. If Congress levied a tax only on Lithuanian Americans, you don't fix that by levying the same tax on everybody. You invalidate the legislation. If Congress wants to extend the tax to everybody, let them pass that. Some academics have nevertheless suggested that disparate impact can be fixed by applying it to everybody. I, for one, don't see it, even if we do apply it to white males, and that's the standard line now, so I hereby adopt it. It doesn't help. It doesn't solve the problem. Equal protection is about individuals. It's not about groups. If one applies disparate impact liability, for example, to the NBA, to aid whites who are underrepresented, and to the city of New Haven, they apply it to aid African Americans, because in that situation, African Americans were underrepresented. That doesn't even things out. Frank Ricci was qualified for a promotion at the fire department. He doesn't come within 1,000,000 miles of being qualified for the NBA. It doesn't help him. So to put my point differently, if half the industries in the country decided they were going to discriminate in favor of African Americans and half were going to discriminate in favor of whites, that's not equity, that's a whole lot of discrimination. If the industry that you're most qualified for discriminates against your group on the basis of race, you're up the creek. So given this, I think it's hard to avoid the conclusion that Griggs-style disparate impact liability that on its face demands discrimination in favor of a particular racial group by saying you need to jimmy the qualifications in a way that better suits that group unless you have a real necessity for doing otherwise. That's going to have to be judged by strict scrutiny. Whether it's being employed overall to help all groups doesn't matter. It can't be employed to help all individuals. So the question is, can it survive strict scrutiny? In the post-Grutter world, where strict scrutiny turns out to be less strict than we thought, I think the answer is probably no, at least not in any form that can be called a Griggs-style disparate impact liability. As I'm thinking right now, and maybe you can come up with some more thoughts, there are three different possibilities for a compelling interest. First, one could argue that increasing the employment of women and minorities is the compelling interest. But even Lewis Powell in Bakke poo-pooed that one. He said that was discrimination for its own sake. We want to help this group and not that group. Okay, but even if just increasing the employment of women and minorities, even if it is a proper compelling interest, disparate impact liability isn't narrowly tailored to achieve that interest. The truth is that disparate impact liability is an unbelievable mess. We don't even know whether it has a positive impact on hiring any particular group. Take, for example, the EEOC guidance on criminal background checks. Think about what an employer will do if he's concerned about hiring an ex-felon. If he's convinced the EEOC policy makes it too risky for him to even do a criminal background check, he may, I hope he doesn't, but he may resort to straight race discrimination or straight sex discrimination, because of course, for the males out there, and as I'm looking here, it looks like that's most of you, you commit more of the crimes than women do, so an employer might rationally discriminate against men there, as well as African Americans or young people. It isn't right, but it happens anyway. More generally, disparate impact liability causes employers to shroud the hiring process in secrecy, generally to avoid hard-edged rules that might be brought into question as having a disparate impact. A whole lot of discrimination can therefore go unnoticed. We may well be shooting ourselves in the foot if what we're trying to do is achieve more employment for women and minorities. The bottom line on this one is I don't think increasing employment opportunities for women and minorities is going to pass strict scrutiny. Second possibility is diversity in the workplace. I wouldn't be too optimistic on that one either. In Grutter versus Bollinger, the court deferred to a state agency, that is a state university, on whether it needed diversity to properly educate its students. It's not just the court was deferring to academic freedom and academic judgment here, something that's not at issue in the typical employment case, so it wouldn't apply to Griggs. It was deferring to an entity about how to do its job, but deferring in this context, in employment, would require deferring to Congress about whether diversity is a compelling need for employers to do their job. It's really awkward to argue that Congress or the EEOC knows how to run the business of every employer in the country better than the employer does. But even assuming that the court could be persuaded that workforce diversity is a compelling interest, the court has never approved of stark preferential treatment based on race, even in the context of higher education. It's always dressed it up with holistic analysis. That's the point of the parents involved case. Here, we're not talking about holistic analysis. So where's that going to fit into the court's past precedent here? So that leaves the possibility of rooting out actual intentional race discrimination as a possible compelling interest. And I think this is the best shot that disparate impact liability has. But the only way it could make that work is to treat it as if that really is the point. There would have to be a defense available if the trier of fact believes the motivation for the employer's hiring criterion isn't race or sex, isn't national origin, then there's no violation. Nobody disputes that disparate impact is sometimes evidence of discriminatory intent. The point is it shouldn't be regarded as a wrong by itself. It is simply evidence. So I don't believe Griggs-style disparate impact liability can survive strict scrutiny. But what do I know? I'm not a fan of disparate impact liability, so I may or may not be the best person to articulate the argument in favor of it. I'm on record that this stuff is a problem. The evidence is overwhelming that it was not intended by Congress when it passed Title VII in 1964. It is incoherent since everything, as Roger was telling you, everything has a disparate impact on some protected group. By the way, did you know that Cambodian Americans would have an advantage if you wanted somebody with experience in the donut industry? You know, it's a crazy old world, and different ethnic groups often have qualities that are different from other ethnic groups. You know, that's why we argue that diversity is a good thing. It can't be so that diversity is a good thing and yet everybody's alike. All of this ends up making a mockery out of the law. If everything has a disparate impact, then everything's illegal unless the EEOC chooses to ignore it. That gives the EEOC, in the case of Title VII, unlimited discretion as to what sort of workplace rules they want to go after. So here's what I recommend. Here's where the executive branch angle of this issue comes in. Because the administration has a duty to comply with the Constitution, the administration needs to get a handle on this issue. Figure out where the statutes and regulations have been interpreted to extend to disparate impact and where they haven't. Plus, it needs to get a handle on what argument there is for each statute, regulation, or policy as to why it would pass strict scrutiny. So I propose what I call a disparate impact inventory. I would urge the Attorney General to send a letter to all the agencies within the government that enforce any sort of anti-discrimination statute, regulation, or policy and ask, do you consider your statute, regulation, or policy to impose liability for disparate impact? If so, what makes you think it does? And sometimes the answer is going to be easy. You ask the EEOC, why do you think that Title VII is governed by disparate impact liability? And they'll say, Griggs. Supreme Court said so. Okay, that's an answer. In other cases, it won't be so obvious. Example, the Obama administration issued the Dear Colleague letter pursuant to Title VI of the Civil Rights Act, telling schools that their federal funding can be cut off if they discipline African American students proportionally more than they discipline whites. Even if the disproportion, and they're quite explicit on this, is the result of even-handed enforcement of a code of conduct that was not adopted for its racial effect. Because the Supreme Court has repeatedly held that Title VI is not a disparate impact statute, the Obama-era Department of Education purports to rely on a couple of 1966 vintage regulations issued pursuant to Title VI. But as Allison Solman and I believe we've demonstrated in our most recent article, that's a misinterpretation of that regulation, which does not in fact authorize the department, or those regulations, does not in fact authorize the department to essentially increase the scope of Title VI 1,000 times over. But we don't need to quibble about the interpretation of that regulation, even assuming that the regulations generally ban disparate impact across the board, subject to a necessity kind of defense. That just means that by analogy to City of Bernie versus Flores, they're beyond the scope of the executive branch's power. Just as Congress can't claim to be enforcing rather than unconstitutionally extending the Equal Protection Clause by passing a statute that outlaws disparate impact, the executive branch can't claim to be enforcing rather than extending Title VI, which is held to be coextensive with the Equal Protection Clause, by promulgating an all-purpose ban on disparate impact. Finally, agencies that enforce anti-discrimination statutes or regulations or internal policies should be asked to articulate in detail why they think disparate impact liability will survive strict scrutiny. What's the compelling interest? Why is it narrowly tailored to achieve that compelling interest? And have them give it their best shot with full participation by career officials or anybody else who wants to weigh in. Once the Trump administration has that information, they can decide whether I'm right or wrong about the weakness of the argument in favor of disparate impact liability's constitutionality. So I think that's what I have to say here, and I will yield.
Thank you very much, Gail. I'm sure her presentation will suggest some questions to other panelists or members of the audience when we get to the question and answer session. We now have the opportunity to have our very own TED Talk. Professor Professor Theodore M. Shaw is the Julius L. Chambers Distinguished Professor of Law and Director of the Center for Civil Rights at the University of North Carolina School of Law at Chapel Hill. And he drove all the way up here from there last night because his flight was canceled. So we're especially grateful to him for his sacrifice in coming. There at Chapel Hill, he teaches civil procedure and advanced constitutional law and 14th Amendment law. Before joining the faculty at UNC Law School, he taught at Columbia University Law School, where he was a professor of professional practice. He's also been of counsel at a couple of law firms, and most interestingly, I think he was the 5th Director, Counsel, and President of the NAACP Legal Defense and Educational Fund, for which he has worked in various capacities over the span of 26 years. Ted, we welcome you to the podium.
Thank you so much. I'm very glad to be here, and I've been with the Federalist Society many times over the years. I was sitting and talking with Gail before we began, and thinking about over the years how, if I can be presumptuous, our relationship has grown. There have been times when I've been somewhat heated with her. We've had heated exchanges, and we may have some more again. But I'm very fond of her, and I'm happy to be here. Which goes to and Roger and I have bumped heads more times than I can tell you. My wife, among others, says to me, "Well, why do you go to the Federalist Society? You know, why go?" And I have 3 reasons that I can think of. One is, I may be naive, but I continue to think that it's important that I, for one, but I think this is true of all of us, although I can only speak for myself, that I talk to people with whom I disagree. I think we need more of that, not less. Secondly, I'm of the view that I don't think on issues like this and other issues that I want to see the Federalist Society or any other forum in which the views I hold or I believe in are absent or excluded. But that's just me. Thirdly, you all need some kind of piñata. So I'm glad to do that. I thought as Roger and Gail were making their presentations that there's no way I could say everything that I would like to say. We'd be here far too long, and at some point I'd be standing up here railing on, and you all will have left, and I'll still be fussing. But part of what I was thinking at some point was, settle down. It's not quite, I think, at least in my view, what you say it is. And let me give you an example of this. When I think about disparate impact, I think about my time at Justice. I think I've shared this with you all before. Many years ago, this is under the Carter administration. Yeah, I saw that. There was a proposal to bring a lawsuit against a Chicago suburb. I could call its name, but I won't. I still think I shouldn't. But the theory of the lawsuit was a disparate impact theory under Title VIII of the 1968 Civil Rights Act, which, by the way, we commemorated the 50th anniversary of Title VIII just last week. It came in the aftermath of the assassination of Martin Luther King and the violence that erupted in cities around the country. the racial tensions, Washington, D.C. itself, only now beginning to finally recover from the scars of that violence. So the theory of the case was to go after this suburb that was largely, almost exclusively white and wealthy, and to sue it because it had minimum lot size ordinances. Certainly that had disparate impact, not only on black people, but for anyone who didn't have a lot of money. But the theory was to challenge it because it had a disparate impact, particularly on black folks, given the wealth gap between white people and black people. The suit was rejected by the then Assistant Attorney General, Drew Days, and there were some people who felt strongly that it should have been brought. I, for whatever it's worth, and at the time it wasn't worth anything because I was just a line attorney, but I thought that that was the right decision. And I've thought about disparate impact over the years, and I think about it, and I'm someone who has said yes and no to proposed lawsuits in my time at the NAACP Legal Defense Fund, and I thought about it because I thought about disparate impact as not anything that literally has a different impact, as I think my esteemed colleagues seem to suggest. I think of it more as, race is kind of in the air somewhere. You can smell it, but you may not be able to prove discriminatory intent. But nonetheless, the question is whether or not there really is a good justification for something that has a racially exclusive effect. That's how I've thought about it anyway, and I think that's the way many others have thought about it, although you wouldn't know that if you listen to Roger and Gail, and I take them at face value when they say that's what they think people are talking about. I go as far as to say it may even be that there are some people who would say anything that has a different impact should be subject to the disparate impact theory. That would be a mistake for all kinds of reasons, including the fact that courts just aren't going to go there. I think that strategically it would be a mistake. Having said that, let me say something about the Fair Housing Act. The Fair Housing Act, if you go back and look at its legislative history, with all due respect to the late Justice Antonin Scalia, there's an affirmative aspect of the Fair Housing Act. It was meant, unlike some of the other civil rights statutes, to actually encourage and produce racially integrated living patterns in the United States. Now, somebody may not like that, but that was the intention of the statute. And if you think about, or you accept that intention, and it may be that we'll have an argument about that or disagreement, but if that was the intention, then you get Congress thinking differently about how that statute should be applied than if you're talking about other kinds of discrimination. A word about Griggs v. Duke Power Company that is an entree onto or into a bigger point here. Griggs was a case that involved jobs that were not really high-skilled jobs. But you found black folks excluded as a matter of course. And so the lawsuit, which was brought by Julius Chambers, you might have heard that I hold an endowed chair in his name. Julius was my boss at the Legal Defense Fund at one time. He was the third director counsel. He was a friend. He was a mentor. And in many ways, whether we're talking about voting rights, jingles, or the cases that that Roger alluded to with respect to disparate impact and the Voting Rights Act, Section 5, or whether we talk about school desegregation, the Swan versus Charlotte-Mecklenburg Board of Education, or in employment, Griggs v. Duke Power Company, or Albemarle versus Moody Paper Company. Julius litigated those cases, and so I lift his name up all the time because Julius helped to change North Carolina and the country. And so in some ways, I'm fighting, for his legacy, and he made the country better. So here was Duke Power Company that didn't hire black folks in these non-skilled positions. And what Julius argued is that if you see this disparate impact or this exclusion, they should have to justify it. If there's a qualification that's necessary for the job, it's not that gets thrown out the window. There's a discourse that we've heard throughout this presentation today, which seems to suggest that this is about quotas, unqualified people, etc. I think it's more about whether our starting place in our world is that if we see an exclusion, either almost entirely or entirely of a certain group of people because of who and what they are. Actually, let me reframe that, because as soon as I said because, that sounds like we're talking about intent. But it has an impact on people. If we measure them by who and what they are, then we can either say, well, you know what? We kind of either know or we think we know. We may not speak it. Why they're not there. Some people think it's because they're not qualified. Other people might think, let's look behind this and find out whether it's actually necessary and whether it's justified. And if it is, see Washington versus Davis, if you want to talk about the 14th Amendment. Sure, you have to prove intent. If you're talking about Griggs v. Duke Power Company and you're talking about Title VII, if you have a justification, you may survive a challenge. But if it's unnecessary and it has an exclusionary impact, then you may have to change your practice or your policy. Tell me why that's so terrible. Tell me why that's so bad. It depends on where you start in the world and what you believe and what you're comfortable with, I suppose. Just a few more points, because as I said, I can't get to it all. Let me say a quick word about both the issue of school discipline and criminal background checks. There's more and more consciousness, not just among people who are racial minority group members, not just black folks, for example, of how our criminal justice system in this country operates. Some people are just fine with it. But I think more and more people have awakened to the fact that this is a broken system in many ways, and that it reifies racism in many ways. Let me be clear. People who rape and kill and stab and etc., they need to be prosecuted. They need to be incarcerated to protect society. But we're talking about a criminal justice system which incarcerates more people because of nonviolent drug offenses than anything else these days. And largely they're black and brown people. I said to this gathering or gathering like it last year, that I'll be blunt. There's a lot of white folk who use drugs. They are not arrested, charged, prosecuted, convicted, and incarcerated at the same rates as African Americans. Am I going to tell you that I think that that's a problem? Hell yeah, I'm going to tell you that. And do I think that that disproportion is something we ought to do something about? Yes, I do. I just keep thinking about how a few years ago, all of a sudden, I started seeing these news shows, these teasers. The new heroin addict, and it's not who you think. News at 7. Well, it was, white suburban housewives. Now all of a sudden, heroin, opioids, all these drugs, they're health problems. We need to help these folks. Yes, we do. But I think about the demonization of black folks, for years and years, and the incarceration that still disproportionately defines our criminal justice system. The way into that system, disproportionately, is school discipline problems. It's not that we shouldn't do something about people, children, students who misbehave in schools. The GAO just came out with a report that I know Gail will have something to say about it, and she has an article recently about this issue. She holds her views in good faith. The GAO report is about school discipline and how it's implemented disproportionately, and whether there are alternatives to the way we handle school discipline issues that don't end up incarcerating children at a young age and putting them on a path toward incarceration as adults. And part of the problem also is that even similarly situated young people in schools, part of it, not all of it, is if they misbehave in the same ways, there's a different consequence for black and brown students than for white students. So one other related issue, hiring people with criminal records. Our criminal justice system, as I indicated, is broken in profound ways for the reasons that I talked about. So you get all kinds of disproportionate consequences. And when it comes to employment, my view is, and the view of others has been, if you have people with criminal convictions, felony convictions or other convictions that are not felonies, and that gets in the way of making them productive citizens, they can't even get employment because they experience civic death. What I'm talking about is they can't get jobs, they can't get loans, they can't vote, go on and on and on. If the job is somehow related to the criminal conviction, nobody wants people who are convicted of abusing children working in daycare centers. That's not rocket science. But if somebody has a record of smoking weed, nowadays, it's legal in a lot of places and people are making a lot of money off of it, but there's still a lot of black and brown people who are still incarcerated for it. Should that get in the way? You don't want them flying airplanes probably, but, should we revisit the impact of these convictions? I think we should. Look, I want to end on a point that I don't have time, and I wish I did, because God knows I can go on and on about this. Grutter, Bakke, in fundamental ways, Bakke was a betrayal when it comes to African Americans of the 14th Amendment's application. And the original purposes of the 14th Amendment. Anybody wants to come at me about that? Come on. I'd be glad to have that discussion. And what you ended up with is the university's rights rooted in the First Amendment in academic freedom. I've spent a good chunk of my life working to defend Bakke, but there are things about Bakke I was unhappy with on the day it was decided, and I happened to be on the court on that day in the Supreme Court, and I've been unhappy with ever since. We don't have time to discuss it, but next year, 2019, is the 400th anniversary of the arrival of African Americans in what's now the United States. The issue of race and the issue of African American treatment in the United States has always been, and in many respects continues to be, this nation's greatest challenge and dilemma. For those of us who believe that the disparities that we see as measured in health, wealth, employment, education, I can go on housing, I can go on and on. For those of us who believe that that's some kind of, dare I say, serendipitous consequence of non-discriminatory action, I'll never get you to agree with me. But anybody else who's thoughtful about it and who cares about these issues, I hope you engage in thinking about the unfinished work in particular. Not that I don't care about everybody else. With respect to African Americans, it needs to be done. And the kinds of policies and practices that we need to be open to address all that. If that is escaping you, my apologies. But if it's not, I'd be happy to talk to any of you about it.
Well, thank you, Ted, for that very thoughtful presentation to us. We're going to begin our question and answer session now, and I understand that we have about 45 minutes until 4 o'clock, since our next event has been pushed back a little bit. So plenty of time for questions and answers from anybody who would like to ask questions, and I think maybe we'll start with our panelists, if that's all right. Would any of you like to comment on any aspect of another presentation?
Well, I would. Let me, and I'm going to be commenting on what Ted said. He made the point that, his definition of the disparate impact approach is that where discrimination is in the air, but you may not be able to prove it, and so instead we ought to be able to turn the tables on the defendant and require them to come up with a good reason. I think I did anticipate that. This is the argument that it's hard to find, a smoking gun in these cases. My response would be, first of all, I don't think it is that difficult to find a smoking gun. You can use statistical evidence, you can use all kinds of circumstantial evidence, and they said, I had no problem when I was in the Civil Rights Division proving these cases, and I'm sure, Ted did not either. But if you believe that, then you should also be willing to give the defendant the opportunity to prove as an affirmative defense that he wasn't discriminating with an illicit motive, that his policies were not motivated by race. And I think that this is what Justice Scalia raised as a better approach in his concurring opinion in the Ritchie case. When you think about it, it's a little bit odd, but that's not the way it works now. We have redefined the offense so that it's really not discrimination anymore that we're after. It's racially disproportionate results. And the analogy that I've drawn is it's as if the government were to say, these arson cases are really hard for us to prove. It's hard to prove when people deliberately burn down their homes. So we're going to redefine arson as being simply burning down. If your property burns down and you own it, then you're an arsonist. And we're not going to give you the opportunity to prove that it was an accident. I mean, the government is redefining, what the crime is. So there really isn't what the original meaning of the crime was, in the first place. Ted then raises the sort of broader issues about the criminal justice system and racial disparities and all that. I do not think that the criminal justice system is broken. If you do think it's broken, go ahead and fix it, but don't screw up the rest of the law, while you're doing that. I mean, I think that Heather McDonald and people like that have the better arguments that the system is not racist, is not hopelessly slanted against African Americans.
Ted, do you have a response to the point about a defense to a disparate impact claim? You seem to be expressing agreement with Roger at one point during his discussion.
Yeah. Well, I think the whole idea of when we talk about, for example, Griggs v. Duke Power Company, the whole idea of rebuttable defenses does a lot of, and could do, and would do, should do a lot of work here. Mm-hmm. If you show that a job qualification is necessary, the law, in spite of what some suggest, isn't that you have to hire the unqualified person. On the score of smoking guns, people are a lot more knowledgeable and sophisticated about discrimination. I don't throw around the term, although probably a lot of people wouldn't believe it, racism easily. I don't. I used to tell the lawyers at the Legal Defense Fund, whom I directed, don't let me see that word in a brief. Don't call somebody racist. Talk about, write about, give the evidence about what they did, and it inevitably leads to the conclusion that somebody might arrive at about what their motivations might be. But people, for the most part, don't say what they would have been more comfortable in saying 50 years ago or 40 years ago. It isn't that there isn't racism anymore. I heard somebody say last week at a conference at Duke, when he talked about this conference on statues and monuments, and he talked about, because it was very personal for him, it was his family, they owned slaves. And he said his ancestors, the slaves were in his family's property, but they were happy. Well, that's an old trope. You're working too hard. My point is this. There's still a lot of inequality. And the question is which way our system goes. Do we assume that inequality is the consequence of just who and what people are? Qualifications, etc. Or do we assume that there's some things that we still have to work on, and we're going to do our best to weed out unnecessary effects? As to, Roger, your statement about the criminal justice system, I can't even begin. I can't. If you don't see that,
well, I don't.
God bless you.
Well, thank you.
But with all respects, I think it's blind.
Well, okay. I don't think that it is. I think that even Michelle Alexander, in her book, concedes that while she thinks that a lot of things are made criminal that shouldn't be made criminal, she concedes that violent crimes are just that there is not racial equality among who commits violent crimes. the disproportions that we see
I think I spoke to that.
What?
I think I spoke to that.
Well, you said that you were opposed to violent crimes, but my point is that you see these racial disproportions with respect to all crimes, and you see it in the criminal justice system generally. It is the fact that crimes are committed at different rates by different racial groups, for a variety of reasons. That is the reason for these racial disproportionalities, not because racist prosecutors, racist policemen, racist laws. The reason for the persistence of racial disparities in this country is, I'm not saying that racism doesn't exist, but the reason for the persistence of these racial disparities as racism declines, and if you don't think that racism is declining, you're the one who's blind.
I didn't say that racism is not. I didn't say it's not declining.
Okay.
Do you agree that it is?
Pardon me?
Do you agree that it is?
Oh yeah, we're much better than we were, 50 years ago.
So the reason,
although we've seen a resurgence of some racism, I mean, look at Charlottesville.
The reason that we see, well, look, there are always going to be kooks out there.
Finish your comment, and then we're going to go to Gail.
Okay. The reason that we see these continuing disparities is, the single greatest reason is because of disproportions in out-of-wedlock birth rates. 7 out of 10 African Americans are born out of wedlock. More than 6 out of 10 Native Americans are born out of wedlock. More than 5 out of 10 Latinos are born out of wedlock. Fewer than 3 out of 10 non-Hispanic whites are born out of wedlock, and fewer than 2 out of 10 Asian Americans are born out of wedlock. That is a huge range, and it is not a coincidence that how well different groups are doing with respect to who's committing crimes, who's doing well in school, who's unemployed, who's in the school-to-prison pipeline, all of that tracks whether or not kids are growing up in a home without a father. That is the problem that needs to be addressed. And you are not going to fix that problem by telling employers that they have to hire with an eye on race, which is what the disparate impact doctrine does. You're not going to solve it by telling universities or by letting universities discriminate against Asian Americans and white students in order to get their numbers right. And by the way, the problems that children have growing up in a home, without a father is true within racial groups as well as among racial groups. White kids, who are growing up in a home without a father are more likely to get in trouble and have all these, social pathologies, too. That's the problem that needs to be addressed now.
My turn.
Your turn. And then, Ted, you can weigh in after Gail if you like.
Because this is a panel on disparate impact, not on the criminal justice system. I'm trying to figure out, hold on. I actually sometimes think that you should be a Federalist Society member, because there are a lot of ways in which you think like everybody in this room, and I think that's why you like coming. But there are also ways in which you really don't think like a Federalist Society member. And the biggest one...
I acknowledge that.
The biggest one, I think, is that you have a much happier view of like federal bureaucrats creating policy out of nothing. And like, for example, with disparate impact, you seem to think it was interesting, like they had a chance to sue this suburb of Chicago, and then they decided not to. And it's, some people were upset about that, other people weren't. Maybe after you left DOJ, a different decision was made on a case that you would have disagreed on. It doesn't, my point is, Congress is supposed to set the policy here. And if we give that much discretion, so if everything has disparate impact, and everything does, and everything does, and the notion of don't worry, federal bureaucrats will only pick out the things that really are getting at discrimination. Well, that's not criminal background checks. When somebody decides not to hire somebody because they have a criminal record, it is much more plausible that they care about criminal record than they're using this as a way to discriminate against African Americans and men. That would mean like they all want to hire Asian women. No, they actually care about criminal background. And they don't want to hire somebody with a criminal background. I agree with you that we need policies that will make sure that people who are getting out of prison get jobs. I agree with that. I am concerned that people on the left spend all their time worrying about whether they have the vote because they think it benefits elites on the left who will then get elected, and not enough time worrying about...
Oh, no, that's not the reason.
And Ted, hang on just a minute. But before you respond, let me invite those in the audience who would like to ask a question of this lively panel to line up behind the microphone, and as soon as Ted is finished responding, then we'll go to some audience questions.
We actually have policies that are meant to promote hiring ex-felons, and I support those policies. But twisting a law that has absolutely nothing to do with that, I think, is a grave mistake against the rule of law, and it basically causes, the whole body politic to be infirm. You have to actually have the policies that are adopted in democratic ways and not created in the basements of some federal bureaucracy that are aimed at a problem that is different from the problem that they're authorized to solve. The EEOC is authorized to solve the problem of actual discrimination and not the problem of needing to reintegrate felons into the mainstream. It's an important problem, but Congress needs to deal with that, and they have to some degree. On the question of whether or not the defense to disparate impact is enough to make this not much of a problem, the case you mentioned, Albemarle Paper versus Moody, I mean, what a case. That company actually hired an industrial psychologist to conduct a study of whether or not passing a particular test made employees better at that place of employment. And that industrial psychologist found that indeed they did, but the Supreme Court said that there wasn't enough data to be statistically significant. Well, there never will be enough data to be statistically significant. If I own a shoe store, I cannot prove that hiring polite salesmen sells more shoes than hiring rude salesmen. I could be wrong on that, but my intuition is that polite is better. I can't prove any of the things to the degree that Albemarle Paper would have required. The Supreme Court tried to back away from that and say, well, it's okay if it's just a legitimate purpose, which sounds a lot nicer. It sounds a lot more like what you were talking about. But the traditional civil rights groups went bananas over that.
But Gail,
and as a result, we got the Civil Rights Act of 1991, which goes back to the earlier standard, although it doesn't define it.
Gail, as I remember that test and that case, the employer hadn't been using those tests until the issue of whether black folks in significant numbers were going to work at that company came up. And then it became the
So
screen.
it's fine as evidence of discrimination. I have no objection to, gosh, they just came up with this stuff at the last minute. That was true of Griggs. I don't know if it was true of Albemarle Paper. But remember, at that time, that's when these exams were first becoming available.
But it
so
was
it wouldn't
facially,
be surprising.
But it was facially neutral. And
use it as evidence of discrimination.
Well, hold on a minute. It was facially neutral. And if you had to prove discriminatory intent by just showing that there was a test, there was nothing on it that said, we're going to apply this test to black people only.
You're not limited to that, though, Ted. You can enter into evidence the fact that they had this test and they didn't bother to use it until black people started to apply.
You can also say that the test was not necessary for the job that they were applying to.
And that's exactly my point. You don't trust the employer to decide what's good for the employment, and I don't trust the bureaucrat or the court to tell me what is good for that place of job.
You're right.
What do these people know about paper making?
That's what
On that happy note,
why I don't think about this in the way that Federalist Society folks and conservatives think about it. Yeah, you can beat up every decision by saying it's some government bureaucrat. There are some instances in which the government doesn't work well, and there are other instances where it does do some things, in ways that are fine with me. Okay, other people don't believe that.
First audience question. Yes, sir.
Thank you very much. Wayne Abernathy with the American Bankers Association. follow up on Professor Heriot's suggestion on how to address the problem or abuses of disparate impact in bureaucracies. 2 real-world examples. Right after the Inclusive Communities case, which found that disparate impact is cognizable within the Federal Housing Administration, but the court also said it can be abused, and so it has to be within 4 corners of how it's applied. We sent a letter to all the banking regulators, and we said, are you going to apply the Supreme Court standard in your rules, regulations, guidelines? And they all said, well, we already do. Well, if you talk to any banker, they would disagree with that because they're finding significant applications by the bank regulators that are inconsistent with the Supreme Court case. So that kind of limited the question of calling the regulators and saying, well, justify your use. Second case, today, or maybe tomorrow morning, the Senate will vote on guidelines, which have been determined to be rules, dealing with disparate impact and indirect auto lending, say under the Congressional Review Act. And they will probably throw that rule out. There was already a vote taken today on proceeding to that passed in the Senate, so they'll have a vote to eventually throw that out. The point there is, by actually going to Congress and getting Congress to weigh in on this, that seems to be having a much more significant effect than just asking the regulators, justify yourselves on what you're doing. So I put that as forward as real-world examples of maybe how to get at those abuses.
Thank you.
And speaking of the Congressional Review Act, here's Todd Graziano.
Todd, a question from you.
Sure. Todd Graziano, as Roger said, from the Pacific Legal Foundation, and since you heard I do have a question in a second, helping sponsor the reception. It's my understanding from text that Senator Sass won't be here, so the next event will be the reception. That will be moved up in the Chinese room, so we can continue this discussion if it's not resolved with alcohol.
But not with microphones.
Right. But I wanted to thank Ted and then ask my question of him. Thank him again for driving up. And unlike that pig-headed Roger, I am sometimes convinced by you on really tiny things over the years. And even though you don't convince me on many things, I still learn so much from kind of hearing where you're coming from. But my question to you is, I think the exchange that you just had with Roger on the fact that the disparate impact as a legal cause of action doesn't allow a defense, to me, does make a difference. You're never barred from using disparate impact to prove actual discrimination, and sometimes it's powerful and sometimes it's not. If it is so powerful, why aren't you content with it just being evidence? If there are situations where disparate impact speaks for itself and you've used it in your prima facie case and the employer can't rebut it, why isn't that enough? Why do you need it, or why should we need it to be a cause of action for which there is no defense?
Yeah, I think I hear that point, and this is I think this is very much a worthwhile conversation, and in my view, I think because I acknowledge that there are all kinds of things, maybe everything, has some kind of disparate impact, but I'm not saying, and within the civil rights community, I think any thoughtful person really isn't saying anything that has a disparate impact should be illegal. I think the key to this is, as I said, and I don't know if you're going to find this helpful. For me, it's always been, some consciousness somewhere of race and the disparate impact, but also the question of whether or not the policy that's at issue is one that is necessary and justifiable, whether it's needed to do a job, for example. The minimum lot size, My guess is that the people who adopted that policy on that city council, I don't think they were thinking about race. I think these people had so much money and wealth in that community. That's probably what they thought about more than anything else, but they were thinking about uniformity, aesthetics, and all those other things.
They were thinking about wealth. I mean, 5 acres is a lot of land. And if it's the town I think it is, they were trying to exclude people like me.
Well, that's right.
And most of us, not everyone in the room.
Right.
But,
They didn't want to see
That's right. I acknowledge that. And so, but I'm saying there are all kinds of things that have disparate impact that, I'm not thinking should be subjected to a race discrimination claim.
Well, see, you're a reasonable guy, but if you've written the law in such a way, or you interpret the law in such a way, that, unreasonable people are going to be able to bring lawsuits too. People who either misperceive there being discrimination in the air, or who don't care but think that they don't like this employer, or they think that they have a winning lawsuit.
Well,
not everybody is a reasonable bureaucrat the way you were.
Well,
you have unreasonable plaintiff's attorneys out there. They sue anybody.
I'm not even going to be tempted to say thank you to that. But Roger, look, the thing is that even in another era, when the judiciary was not as conservative as it is right now, even for that moment in which there were more judges who were more liberal, judges were very unlikely to rule in favor of plaintiffs who brought those kinds of claims. I've spent most of my life as a lawyer fighting uphill with respect to judges and what we could win and what we couldn't win, what we could convince them about and what we couldn't convince them about. You don't just waltz into court with a case with anything that has a disparate impact and put it before a federal judge and think you're going to win.
Well, but you think that litigation is this frictionless, costless machine. That is not the way businesses look at it. It is not easy to win a lawsuit. They want to avoid lawsuits. They want to avoid being put in a situation. I mean, it's not great assurance, for a guy's lawyer to say, well, sure, in theory you could be sued and you could lose and you wouldn't have any very good defense, but I don't think anybody's really going to bring the lawsuit, and probably you're going to get a judge who, after a lot of discovery and paying all your lawyers and everything, is probably going to rule in your favor. That is cold comfort indeed.
Also, don't forget the hidden cost here. Employers have learned this game pretty well. They have learned that you do not publish your job requirements. And in general, their job requirements are much vaguer these days. When I was a kid, I used to look through the classifieds in the paper to see whether there was any job I was qualified for. And there were a lot of actual qualifications being, you have to know how to do this, you have to have this kind of certificate. You very seldom see that relative to what you did before. So you can hide a lot more discrimination. Employers have learned, don't tell people what the job qualifications are. Have we actually done something that has increased the likelihood, that jobs will be given out without regard to race? We may be doing just the opposite. We're creating the potential for hiding it.
Here's my frustration with this discussion, with the discussion about what used to be affirmative action and is now diversity and admissions in colleges, et cetera. To hear some of these conversations, you'd think that these job categories, these employment opportunities are just full of African Americans and Latinos, et cetera, or these colleges and universities, the University of North Carolina, now subject to suit, Harvard subject to suit. You'd think that you had black students taking positions there in enormous numbers. I mean, for God's sake, we're talking about black students at these institutions being somewhere around 5%. What's the underlying assumptions about these issues that inform our conversation?
I think that you are... those arguments are sometimes made. They have not been made this afternoon. I think that the point that Gail and I have made over and over again is that employers are being discouraged from hiring the people that they think are the best qualified. It's not that they think that, that we're objecting to there being too many people of this color or that color. And indeed, the point that we're making is that the point that we're making is that any employment criterion of any kind is going to have a disparate impact on somebody, and you can define it in terms of all kinds of racial groups, subgroups.
And if it's job related, then it should
religions, whatever. This is not about vilifying, minorities or anything like that, Ted. That's not what this discussion has been about this afternoon.
Why don't we go on to the next question?
Good afternoon. I'm Steve Gannon. I'm General Counsel of Citizens Bank. By the way, Professor Schaerr, thanks not only for driving up from North Carolina, but for the dignity and civility of your remarks. You don't always see that these days. I wonder if we have a path through the woods a little bit, at least for some of disparate impact. And I want to hark back to some of Wayne's comments around auto fair lending. The big deal in auto fair lending in discussions with the CFPB was data, and it was their models. So there are a lot of car loans made out there, and it was the capture of the data and how that data was assessed to figure out whether there in fact were differences in terms of races and other classifications. And the CFPB preferred a model that had no controls. They liked the raw data. I personally think, given my perspective, that it was because that produced a certain result. The industry wanted data that had controls, but neutral controls, meaning FICO score, geography, used car versus new car, et cetera. And so my question is, can't we at least make some headway in disparate impact if this administration, through OMB, gives directives to agencies to say, develop your data and develop your models. Do it pursuant, for example, to the Good Guidance Bulletin put out back in 2007 that calls for participation. And then once that guidance is developed, then submit it to Congress under the CRA and get it blessed by Congress or not. That way you have transparency, you have real analysis, you have input, and then you want to have a product at the end that maybe not everybody will be happy with, but at least it will be better than a shot in the dark or Professor Harriet, your nameless, faceless bureaucrat somewhere. So what about that as a pragmatic solution or something along those lines?
Thank you. Reactions from the panel, and then we'll go to a question from Jean Meyer.
I don't have enough information to say anything useful here. I'd have to see what the data, what exactly we're talking about. So I'm happy to talk about it, but I'd need more to respond.
Yeah, I would just say sounds to me like a worthwhile conversation. That's as much as I can say right now. I think you opened it up by saying, making a reference to this administration. I know that the civil rights community, and I would say for good reason, is very distrustful of this administration on these issues. But putting that aside, the conversation itself that you're pointing to, I think sounds to me to be a worthwhile one.
As I understand it, the question you're asking is whether, for purposes of determining disparate impact, you ought to use sort of sound statistical methods, right, to determine whether there's an actual impact. And there are certain statistical methods that are viewed in that community as being sound, and other kind of statistical methods, like using just the raw data, that are viewed as being not sound.
And for many of the debates about auto fair lending, but it also goes to housing as well, where you have essentially big data that's subject to being modeled, and it's subject to different algorithms. That's entirely the argument, because you have a body of data and it can be sliced and diced in a dozen different ways. The agencies typically like to slice it, it seems, and I don't have a vast body of experience, but in my experience, they seem to take a certain perspective. The industry takes a different perspective. And however you wind up with the data, that's pretty much the determination. So by the way, Mr. Clegg, I'm not in the business of buying lawsuits either. You're 100% right. It's painful, it's expensive. Boards don't like them. It's not a good thing for us. And any bank would try to avoid it if they could. But if you have better data and better analysis, then it's not such a shot in the dark. I mean, institutions realize we stub our toes all the time. We're happy to step up to the plate and say, you know what, we tried to go left and we went right, let's fix it. But if it's just kind of a standardless process that we're trying to wander through and figure out how to go forward, how do we plan? How do we give guidance? How do we make strategy for the benefit of our shareholders? It's really hard to do. But if you have some good data and good analysis, that is the equivalent of guidance, because think about what we're talking about. We're talking about trying to give a perspective as to how the agency views potential violations of the law. And then, pointing at Todd here, is submitted to Congress under the CRA so it can be blessed or not blessed, then there shouldn't be a problem. We should have a pretty clear path going forward, it would seem to me.
Well,
Roger, did you have a reaction?
Unlike my mealy-mouthed co-panelists, I will come down foursquare in favor of good data over bad data. However, this whole thing sort of creeps me out. I mean, I don't, you know, so you get all this data and you have these banks looking at it and they're saying, okay, now we are going to come up with what our lending policies are going to be in order to reach certain politically correct racial results. We have to be very careful,
Objection.
you know, about not, you know, even though this may be the policy that makes the most sense and will make us the most money, and is being adopted without any, you know, without, and we come to that conclusion without looking at, you know, the racial part of this Excel sheet at all. Oh my gosh, now that we look at this column under the Excel sheet, we see that we're open to a disparate impact lawsuit. So we're going to have to come up with some other policy so that the numbers come out to be politically correct so that we don't get sued. That is exactly the kind of race-based decision-making that the civil rights laws originally were supposed to stop.
I wish it were that simple, but it's actually not. So we're obviously in the business of making money. We like to make money, so do our shareholders. They like it when we make money. And at least in my experience, what I'm talking about is better decision making. In other words, we can't simply make a decision based on one factor. It has to be an entire sort of constellation of factors. So yes, we want to know what that data says and what the models say, because we want to, in fact, assuming disparate impact stays in place, we want to make sure we're not acting in a way that is disparately impactful of certain populations. But what we also can do is look at things like our credit boxes, our disclosures, how we sell in certain areas, what products, you know, do we want to emphasize a particular area versus another to make sure that our profitability stays where we want it to be? Because obviously we've got targets, we've got risk thresholds that we have to deal with. And so it's not the determining factor. It is a factor, however, that we would want to take into account. And my thirst is just to have better information.
Okay, I get it. So easy. You're making yourself a pigeon for my lawsuit is what you're saying.
Your lawsuit being what?
On the constitutionality of disparate impact.
Oh,
okay.
Conceivably.
Okay.
But before we get there, and if disparate impact is unconstitutional, well, we'll put that to the one side, and we'll still have credit boxes, and we'll still have analysis of neighborhoods that we want to lend into, because obviously we have an obligation.
Yeah, but that's just it. If you have big data on this, that means that then I can prove that you would have made more money by doing it a different way. You chose the way you did it because based on race, and you say, well, I'm just trying to do what the statute requires, and I say, well, it's unconstitutional, and then I win, I hope.
I didn't hear him say he's doing it based on race.
Well, no, if he's not, then
you said that's one of the factors.
It is a factor that any business person would want to take into account, and it's a relatively neutral factor. Now, to the extent that the neutral analysis of the data says that we would have made more money if we ignored the data, I suppose you could make that point. I don't know that it would say that, but it's conceivable.
I bet it would. I mean, if you're taking race into consideration, it probably means that there's another way you could have done it that would have made more sense.
Well, let me say a couple.
So you're discriminating.
But I will say, if you're us, though, you have to take the long term. We'd make more money if we ignored
I'm taking the even longer term is my point.
We'd make more money if we ignored our credit boxes. A lot of people in
But you make more money if you don't get sued by the government. But nevertheless, it's a perfect lawsuit because there, you've got a lot of data. So it's clear, this is you're supposed to be loyal to your shareholders, and you are because you're trying to deal with the fact that there is law out there. So I sympathize with your position. Yeah. But it does set up the issue.
Yeah, but it may be that he's also trying to engage in lending practices that are going to be more inclusive and that don't have unnecessarily disproportionately exclusive impact.
Sure, but if the law says you can't discriminate on the basis of race, and they're doing a disparate impact analysis in order to, they believe, comply with the law, but I think the law is unconstitutional when interpreted that way, then you're actually in violation of the law rather than...
Well, see, and this is a core thing and core disagreement, and something Roger just said put it in my mind also. I meant to say this earlier. You talk about the law, the purpose of the laws, the civil rights laws, was that you don't see race. With all due respect, that wasn't the purpose of the Fair Housing Act. It was to promote integrated living patterns. Go back and look at the legislative history.
By banning discrimination.
Wait a minute.
That's the means.
Well, no. It's an affirmative law that says we want to promote in this country integrated living patterns given what
and the means
we have,
chosen was to ban discrimination. The Patriot Act is to secure the national security, but you don't want to say, well, let's ignore what it actually says and just go for whatever the court thinks or whatever the executive branch thinks is good for national security.
Well, let me tell you that you can be fans of colorblindness. I am not. Let me explain what I mean. Yes, in an ideal world, that would be just fine. The question to me isn't whether we see race, because we do. The question is, what is its significance?
Well, legally,
whether we exclude people or disadvantage them, or whether we include them.
Look, nobody's in favor.
You'll be just fine if we just don't see race, no matter what the result is. Even if it reifies all of the inequality that we continue to have. That's a different view of the world. And one other thing, Roger, with all respect, and you and I have gotten to the point where I can say we're colleagues on some level and friends, but when you throw around, the terms like political correctness to characterize what at least I'm trying to talk about, it doesn't advance the conversation.
Well, look, it's a shorthand, Ted, to mean a racial configuration that is acceptable to people on the left. Okay? Now, so I use the term political correctness, and that's, I think, a valid shorthand. I'm sorry if you don't like it, but that's what it means, and I think that's what most people take it to mean.
Why don't we go to a question from Gene Meyer?
Well, I wanted to pick up on the, first of all, it's been done several times, but I really do appreciate your driving, driving all the way up from North Carolina because this flight was canceled. It was
Wait, Gene, how about me flying from San Diego?
Yeah, but your flight...
I appreciate that.
You flew. He drove.
But after all, would I have wanted to miss this?
But there is something that I also, and also appreciate what you said about discussion and talking to the people we disagree with, which is really crucial for society in general. But I wanted to pick up on, I think there's a sense in which the arguments are slightly missing each other. And I want to explore for a second if that might be correct. And I think right at the end there, we were getting to it. I think to some degree, Mr. Schaerr is saying, the purpose of what I think you're trying to do, and correct me if I'm wrong, if I'm right, let's see what they have to say about it. You're trying to say the law is not, we're trying to make for a better society where blacks and other minorities are included in certain ways they are not currently included, or more thoroughly included than they are currently included. And it's only through some of the types of things you're suggesting that that is likely to happen in practice. And I think your co-panelists are saying, no, it's really important to follow what the, to stick to the, to stick to the law and all of this. I think that's where there's a difference, and I may be confusing all of you, but I think what's going on is you're saying, look, there's a lot of history in the country, a lot of things have been done that are unjust, and there are a variety of things you think will help, and being neutral about things won't help. Is that correct?
Yes, and I'm saying that if there's an unnecessary disparate impact, why not address that? If it doesn't mean you have to hire unqualified people. So I'm, generally that's what I'm saying.
Yeah. No,
yeah.
And briefly, I'd also say one of the things I think they're saying that may be being missed also is maybe things don't work exactly the way, just as they're saying areas in which some of what you want, if you treat things neutrally, it may not be met. Some of what they're saying is, well, if you just say, well, the disparate impact, you don't even, if there's you've got a perfectly good defense if you aren't really doing something bad here. In practice, that defense may be difficult. So you may have that problem on both sides. It's difficult to defend against the disparate impact lawsuits because of the cost of defense, both financial and time and emotion, and it's also
reputational
and reputation. But it's also on the other side, and it's something which has bothered me at times. I think there's sometimes on the conservative side a failure to fully take on the argument that equal treatment in certain situations isn't really equal due to past circumstances or status of things or the way things have gone. And I think that's probably partly what you're saying. So.
Yeah, to me in the end, it's a question of what we're comfortable with. Whether we are comfortable, some of us may be comfortable with living with racial inequality and exclusion because we're comforted by the fact that we are now, we can assure ourselves that we're now colorblind, and that's the most fair thing. And others of us, I for one, believe that I am not comfortable with the legacy and the continuing racial inequality in this country. And I want to see us use the tools that we can use to change that. But it's different worlds, The criminal justice system, Roger and I got a lot of work to do. I don't see how people see it that way. Roger doesn't see how I see it that way, or at least it seems like he doesn't see it. I hope it's that, rather than not caring about that. But that's why I believe it's important to come and talk to one another.
Yeah.
I think it's a mistake, Gene, to write laws that permit or encourage people to be treated differently on the basis of race, even if you're doing it in order to level the playing field. And I don't think that those are the way, and that is certainly not the way the text of the civil rights statutes were written. By and large. I mean, there are some statutes now that have disparate impact, provisions in them. But I think that there are constitutional problems with writing statutes that way, that permit or encourage people to be treated differently on the basis of race, even for enlightened reasons. And I think in the long run and in the short run, you lose more than you gain when you do that. And I think that, as I said before, I think that the reason for the persistence of these racial disparities is not because of racism. I think it's because of the single greatest factor is the implosion of the black family. And I think that that's the problem that needs to be addressed. And that you have both cause and effect here. But I think that the disparities are as much the cause of racism as racism is the cause of the disparities.
Ted, last word, and then we'll close.
Did you see the report that was in the Times a couple of weeks ago about black men, boys, men who were the sons of middle-class and even upper-class black families? And nonetheless, what happens to them with respect to their lives, opportunities, etc. This isn't just about, children raised by single mothers. I acknowledge that there are all kinds of issues. And by the way, this is a phenomenon that is happening in white America in terms of single motherhood.
I said that.
It's happened in France. I saw a story about it there, etc. But whatever the merits of that may be, and may be important to talk about it, there's a dynamic. There's something else going on here that continues to be, in my view, and I'm not letting it go yet, the legacy, of what I was trying to get at earlier. Do the math. I said, 2019, almost 9 out of 10 days of people of African descent in this country have been spent under either slavery or Jim Crow segregation. And yes, that had impact on black communities, black families, black individuals that reach into the present. But we have a great deal of inequality, and I don't think that it's going to be solved by just blaming people who are at the short end of that stick.
Brad Wilcox talks about that New York Times article.
Thanks to all of you. Thanks to our panelists. Let's give them a round of applause.